The court proceeds. Now, before court is an application for abandonment of bail in respect of the third applicant, that is accused number 7, brought by the respondent. Now, the law provides as follows with regard to abandonment of bail. In the case of Ace versus Moore State, CR 141 of 2023, High Court of Namibia Main Division, delivered on 4 December 2023, it was stated as follows at paragraph 20. It seems to be wrong in principle that the accused, having initiated proceedings and put his opponent to inconvenience, trouble, and expense, should, at his whim, have the right to abandon the action at any time before the hearing is finalized. We are alive to the fact that that is not ordinarily, excuse me, I'll take it again. We are alive to the fact that it is not ordinarily the function of this court to force a person to institute or proceed with an action against his or her will, or to investigate the reasons for abandoning or wishing to abandon one. An exception, though one difficult to visualize, would no doubt be where the withdrawal of an action amounts to an abuse of the court process. Where the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it is the duty of the court to prevent such abuse. But it is the power to be exercised with great caution and only in clear case. Further, at paragraph 21, the court proceeded, we are of the view that although no ground for the action by the accused was placed on record, there is no evidence upon which we can conclude that the abandonment was done with an ulterior motive. In the circumstances, the court has no legal basis upon which, in the particular case, to review or order the district magistrate to continue with the bail application, as that would be amount to compelling a person to proceed with an action against his or her will, or to investigate the reasons for abandoning or wishing to abandon one. Further, at paragraph 22, it was stated in conclusion, the ruling in this matter should not be seen by counsel and accused in bail applications as an open door to bring applications which will be abandoned if and when the accused so desires. It is therefore important that when bail applications has progressed, the parties can no longer do as they please, without reasonable and acceptable reasons. The court cannot be deprived of its control merely by reason of the fact that the accused has communicated their intention to abandon an application. Now, in the present matter, it is not the third applicant or accused number 7 that had abandoned the application. It is the respondent that has lifted its objection on the application for accused, that is for accused 7, or that is the third applicant, effectively abandoning the application in respect of the third all the 7 accused. Therefore, this court is of the considered view, as the respondent submitted, that after careful consideration, they have reconsidered their position on the available evidence. Therefore, this court is of the considered view that there is no evidence that such a decision was done with ulterior motives, but in the interest of justice. For the foregoing reasons, the following is the order of the court. Accused number 7, bail is granted with conditions. Bail in the amount of 50,000 Namibian dollars with conditions that you must report on Tuesdays and Fridays between the hours of 8 to 1700 hours to the ACC, to the investigating officer, Mr. Inamba. Further accused 7, you must surrender all your travel documents to the investigating officer. Further accused 7, you must not leave the district of Windhoek without communicating or informing the said investigating officer. Further accused 7, you are ordered to surrender all your firearms to the said investigating officer. Further accused, you are ordered not to interfere with investigations or witnesses in this matter. If you do, your bail will be cancelled and you will be kept in custody. The matter in respect of accused 7 is then postponed to 25 August 2025.
Mr. Court, please, my lord. Your worship, just for clarity in respect of the bail amount.
The bail amount is 50,000 Namibian dollars. That is the order of the court.
As the court pleases.
Yes. The passport is to be handed in before or at the time when accused posts her bail amount, and the court will afford her at least, today is Friday, that the firearms must be delivered through the legal practitioner to the investigating officer. Accused number 7, you may stand down.
Yes.
Yes, we can then proceed. You can proceed.
No, Mr. Olunga, yesterday before we adjourned, I was just asking you with regard to the car. Do you remember that?
Yes, I remember that.
This car. Question. Is the Audi of the vehicle? Do you recall that?
Yes, I remember your worship.
Now, when you testified on, let me just get the date. When you testified on the 23rd of July, in fact, you had said you had no idea of this car. Is that correct? When you asked by Mr. Bangamabo, your legal representative, you denied that you have no idea of this car.
Your worship, I remember I denied ownership of this vehicle. Remember it says no. I never said I had no idea about the car. I denied ownership of the vehicle.
All right. The record will speak for itself, but then So, you also said your relationship with Mr. Victor Simaneka Malima was just a business relationship. Do you recall that?
It's a business relationship, and obviously we got acquainted during the time that they were doing business with Namcor.
Just slow down. Cancel.
So, what business was there if your relationship with Mr. Malima was a business relationship for you to take a car that is in his name for service? What business relationship was there?
I mean, he asked me, because he was going out of town, to help him to take his vehicle to the service and to go and take it back once it is done.
The investigating officer will come and testify that in fact you did not drive this car for 2 or 3 days, as you are saying. You drove it for a couple of months, more than 3 months to be exact. What is your comment?
No, I mean, I didn't say I just drove it for 3 days. I drove it for a couple of days.
Okay, but then my question is, if the investigating officer will come and testify that you didn't drive it for days, in fact you drove it for more than 3 months, what is your answer?
Well, you can come and testify to this. I know the facts.
Was this the first time when you took the car for service, as you were saying? Was it the first time that you have driven that car?
No, it wasn't the first time. In fact, I had driven the car, I think when it arrived, I took it for a test drive. So it wasn't the first time.
And you can also confirm that it's an Audi RS Q8. Is that correct?
That's correct, Your Worship.
Did Mr. Malima inform you in whose name that car was registered in?
No. I presumed it was registered in his name since it was his vehicle.
All right. So let's move on to the fuel supply agreement, and I would like to take you to the bundle that was given to you to this court by Mr. Bangamago, your lawyer. It's a page 185. Before I proceed with regard to that document, are you aware?
Council, just slow down, page 185.
Yes, 185.
Yes.
Yes, before I proceed with regard to that document, let me ask you this. Mr. Mulunga, are you aware that ENACOM took over the debts of EcoFuel?
Yes, I'm aware of that, Your Worship.
Okay, and are you also aware that the amount is about 70, let me just make sure, 73 million, are you aware of that?
I'm aware of that, Your Worship.
And is it also correct that you are aware that ENACON also had a debt of 35 million towards Namcor?
I believe so, Your Worship.
Council, just slow down. You can proceed.
Yes, and then that brings the total debt to 108 million. We agree if we add these two amounts.
I don't think that is how it worked.
Okay. So let me take it step by step. Enacon took over EcoFuel, that we are in agreement.
Yeah, they took over the
And
debt.
in
Yes.
other words, they even took over their debts.
Yeah, but I'm not so sure whether at that time the debt that was owed by Enacon to Namcor was 35 million at that particular stage when the debt was taken over. So I cannot confirm.
Okay. From the 53,212,000, we can confirm that an amount of 35 million after it was paid to Enacon. Enacon then paid back 35 million to Namcor.
That's correct, Your Worship.
Okay, and that's where the premise of my question is that the 35 million that was paid back to Namcor after the 53,212,000 was to settle the debt of 35 million. Do you get it?
Yes,
now?
yes.
Okay, now let's get to the fuel supply agreement.
Yes.
So on page 191 of that document, of interest is clause 8.1. Just 192, not 191. My apologies. I'll read it for you, or would you want to read it?
Which one?
8.1.
8.1. Yes, I can read it, Your Worship. All purchase orders issued by the buyer to the seller for products shall be accompanied by a government purchase order of the same quantity and product. No product shall be released to the buyer in the absence of a government purchase order accompanying the buyer's purchase order to the seller.
Okay, let me stop you there. Pardon me, Your Worship, it's supposed to be 6.1. I apologize. On 191. I apologize.
191.
Yes, 191. My apologies.
6.1.
Yes, 6.1.
The quantity of the products, all products ULP 95, Jet 1, lubricants, diesel, all inclusive, purchased by the buyer and supplied by the seller under this agreement shall be between 700,000 to 1 million liters per month, approved credit limit, with a total approved credit limit of 15 million Namibian dollars.
Okay, so with regard to the fuel supply agreement, you agree that the credit limit was pegged at 15 million Namibian dollars?
At that particular time, yes. That's what the agreement says.
Yes, and then you agree with me that the amount then that was owed by that Enacon owed to Namcor by the time the asset purchase agreement was signed was in excess of the 15 million. Do you agree?
No, I don't agree to that.
Okay. If you don't agree, why then did they pay 35 million if their credit limit was 15 million?
No, because the agreement says 35 million if there was any debt, and I cannot remember now exactly how much there was. That I cannot remember.
Okay, let me ask you this, Mr. Momola. We have now established that Enacon took over the debts of EcoFuel. We are in agreement.
Yes.
And then 35 million plus 73 is 108 million.
Yes.
And then I'm taking you to the credit limit to say, well, the credit limit was 15 million, but yet Enacon had a debt of 108 million. Do you see that?
Your Worship, I mean, those details, I mean, I wasn't the one that works with those details. I mean, I'm sure one of the accused will be able to explain that. So I cannot, to be honest, tell you exactly the details of that, because yeah, my duty was really at the level of managing director, and you know, the other colleagues, subordinates, were the ones that dealt with this on a day-to-day basis. So I will not be able to give an authoritative answer to say it was exactly this or that, other than to say that yes, there was a 35 million that was paid back for the debt that Enercon owed, and I also know that yes, Enercon took over the debt of Ecofuels. I think as was agreed by a board, by the board.
And in fact, I'll put it to you that despite the credit limit of 15 million, Namcor continued to supply fuel to Enercon above the credit limit, despite that they owed money, but fuel was still being supplied.
Yeah, again, Your Worship, I mean, those are the things that didn't happen at my level. As managing director at that time, I had people that worked and, you know, and made those decisions. Obviously, after I have signed off a credit limit.
Yes, and in fact, as we stand here, from the 108 million that was owed, only the 35 million was paid. Are you able to dispute that?
Well, the 73 million, Your Worship, as you correctly pointed out, was a debt that was ceded by another. So it's not that Enercon really owed it; it was just ceded as because it was owed by another company. So I think that time, if that was not ceded, the 35 million would have probably been enough to bring Enercon's debt within the credit limit. That's my understanding.
But Mr. Mulunga is an experienced corporate leader. Wouldn't you find it prudent to inquire from Enercon that, look, you took over the debts, pay at least from part of the debts that you took over?
Oh yes, we've definitely done that. We've definitely done that. Over several months, and we, you know, brought these issues to the board. We've had very stringent demand letters that we've sent not only to Enercon but to all the companies that are called Namcor. So I remember very well having done that at Exco level. So we've gone out of our way to, you know, request all these companies that called Namcor to pay up the debts.
Okay, but well, do you know if the debt was eventually settled?
I don't believe the entire debt was settled. I mean, that's why I think they are here also.
So, there was also a reference that was made to the findings by PwC, and by that I would like to refer you to page 248 of Mr. Bangamarwa's bundle. Yes, 248. And of interest is B, PwC investigation. Are you there? Yes, and of interest, I'll read to you that at 6 it says, PwC investigated the following matters. A, unusual data accounts with significant outstanding balances, accounts that exceeded credit limits, and accounts with unusual payment arrangements. Do you see that?
I see that, Josh.
So, in fact, the PwC also, when they investigated, they found out that the payment arrangements that existed between Namcor and the debtors were actually not in a good way, if I can put it that. Do you agree?
Well, yeah, in their opinion, it says it's unusual payment arrangement. That's the opinion of PwC. However, these are the arrangements that were undertaken between Namcor and trading and distribution of Enercon at that stage.
And in fact, they also say that some accounts had exceeded credit limits. You see it there.
Yeah, that's right.
And yet, Namcor, led by you as the managing director, still kept supplying fuel to Enacor, which had exceeded its credit limits.
No, that's not correct. In fact, the credits were suspended at some point because the accounts were indeed over the credit limits.
And you see, on that aspect, the investigating officer will come and testify that, well, despite the credit limit having been exceeded, fuel was just being received for free, if I can put it that way, because it was never paid for, and up until now, it has never been paid for.
Your Worship, I think it's incorrect to say that the fuel was provided for free. The fuel was provided with expectations that it will be paid. Nobody can, no right-minded person would provide fuel to a company for free. So when Enacor, everybody else that bought Namcor, basically was expected to pay back.
And I'd like to say to you that, you see, you are the mastermind or the originator of this whole enterprise that ensnared everyone into it. Had it not, have you taken due diligence as the managing director of Namcor, all this would not have happened.
That is incorrect, Your Worship. We entered into business relations with Enacor and any other client in good faith, with understanding that we are going to provide fuel and then we are going to get paid within the limits of time that are provided by those agreements. That is what we do. So if a client doesn't pay on time or decided not to pay, or they have difficulties in paying for whatever reason, that cannot be my mistake as managing director. I mean, that would be completely unfair to actually blame a non-payment of Namcor debt on me specifically as managing director. Because when you enter into an agreement, sales and purchasing, fuel supply agreement with somebody, and you have, credit that you supply to somebody, you expect them to pay you. And if they don't pay you, surely you can't criminally charge somebody at that level, managing director, for people that have not paid their account.
So, were you aware, firstly, that Enacor was not paying? Let me start there.
I was aware, yes, that Enacor was one of those debtors that were behind. So I was aware of it. And we had discussed this but several times at EXCO meetings. It was discussed at credit committee level, it was discussed at finance and audit committee, it was discussed at board level. We all knew this. We had these challenges.
All right. So if you are aware, what steps did you take to ensure that that does not continue happening?
Yes. Your Worship, we have written demand letters on several occasions. I think we've even attempted to call some of the directors or managers of these companies to urge them to pay. We have at some point actually stopped supplying because of non-payments. And yeah, as I said, we went on very stringent, obviously on the advice of the board, on serious debt recovery programs in the company. And we tried our best to make sure that these companies pay up what they owe to Namcor.
In fact, Mr. Malunga, I'll put it to you that the commercial offer that you made on 8 July was just a tool or yes, a tool that was used by you to get money out of Namcor, which was eventually shared between you and your co-accused persons and Mr. Simaneka Malima. That
This is
is
the court, Your Worship. I have an objection. Your Worship,
Counsel, can you just slow down? Yes.
Your Worship, my colleague for the state, in his question, the way he phrased it, he says that the money which was paid to Enacon by Namcor, of course, at the instigation of the applicant, accused number one. He says that money was then paid back to the accused persons, including
You use the word shared.
shared.
Yes.
Appreciate Your Worship. As we stand here, Your Worship, there is no evidence, not a single evidence, no grain of evidence that applicant in the witness box that he received any cent in his bank account. So the statement by my colleague, of course with due respect, is incorrect. I think he has to use it selectively and keeping in mind that as we stand here, no evidence was adduced by the state, no document was referred to that he received a cent from anyone. Please, the court, Your Worship.
Any response?
no response, Your Worship. I'll leave the question as is. If he has a reply, he can state so. And we move forward.
Yeah, my response is that's totally not true.
But Bishop, an objection has been raised. The court must respond on the objection and make a ruling.
Yes. No, on the record, we did not hear, this court did not hear that there was any money paid to the applicant himself. Yes. Therefore, the objection is sustained. We can proceed. Maybe you can rephrase the question also.
As the court pleases. All right. I'll leave the question for.
We can then move on.
Yes. Now, Mr. Moon, I would like to put it to you that you said you did not run the National Petroleum Corporation properly with due diligence. That's why events like this of credit limits being exceeded, entering into asset purchase agreement without board approval happened under your nose. In other words, you did not exercise due diligence. You ran the entity as you wished.
No, that's not correct, Your Worship. I deny it.
And in fact, even after you had been put on suspension, that's why Namcor, through Mr. Shiwanando Onyema, actually cancelled that agreement because it was a bogus agreement that you had entered into with Enacon.
It's not, I have another objection, Your Worship. Indeed, the state, not really an objection, to be fair to the witness, Your Worship, because during the evidence in the chief, the witness, through documentary evidence, demonstrated that when he was suspended, I think towards March, April 2023, and the cancellation took place towards the end of 2023 by the acting military director. So the reason why such cancellation took place, he placed on record that he doesn't know what transpired. Unless my colleague tells me, put a version to the applicant, to the witness, that Mr. Shiwana will come and tell the court the reason for the cancellation. This is what you worship.
Yes.
Confidence, Roger, just to add on that point, and I think it would, under the circumstances, be fair because there's a letter of cancellation from Mr. Donyema. If my colleague can go to that letter and perhaps see whether in that letter the basis of the cancellation is identified as the agreement is a bogus agreement.
Any response?
We'll leave it for argument, Your Worship.
We can then move on.
So, Mr. Mulunga, I would like to put it to you that the commercial offer that you made to Enacom was just an enabling instrument, if I can call it that.
Your Worship, Your Worship, the question was asked and answered. It's simply now just being rephrased to say enabling whatever, but initially it was posted as the tool that was used to get the money from Namcor, Your Worship.
Any response?
Yeah, maybe Your Worship, just before I answer, I think just for the court decorum, I've seen this practice of Mr. Casper rising when his client is not the one that is being asked. Firstly, Mr. Mulunga has Mr. Bangamabo as his lawyer. The client acts on the mandate and instructions, or the lawyer acts on the mandate and instructions of the client. And Mr. Bangamabo is here. It's different, Your Worship, when an accused is unrepresented, when the court can then assist an accused. I would submit, Your Worship, that a legal representative cannot just rise for the sake of disrupting proceedings. Because what Mr. Casper is implying is that Mr. Bangamabo is not doing a too diligent job to his client. Your Worship, I will also say it will almost turn into a circus where any other lawyer is allowed to object on behalf of a client on which he doesn't have instructions. So I think with regard to the court decorum, that decorum must be followed. The court is not a circus where a lawyer just stands up, objects with regard to questions that were not put to his client. Perhaps Mr. Casper can say maybe he has instructions from Mr. Mulunga, and that is what I will submit with regard to that aspect. And with regard to my question, I was not even done asking, and then he objects. So what was he objecting to? I had not completed my question. That would be my reply, Your Worship.
Mr. Casper?
With the greatest respect to my legal friend, this is below the belt. These are outlandish submissions my learned friend is making. Your Worship, first and foremost, I serve as an officer of this court, and I have on previous occasions informed this court that I am duty bound to not sit idly and allow any injustice to occur. Your Worship, you would recall just a little while ago, an objection was raised. The witness almost went ahead and answered the question, Your Worship. And when I rose and I told the court that, Your Worship, an objection has been raised, the court must rule on it. This court ruled, and it was ruled in favor of the objection raised, Your Worship. And that my learned friend must suggest that I'm imputing that Mr. Bangwango is incompetent, because that's what he's saying, Your Worship. Then, Your Worship, that is where we are throwing the decorum of this court out of the door. And this is what an undertaking we made to this court, that we are not going to allow such behavior, Your Worship. I'm no clown. I'm not in a circus, Your Worship. And I'm executing on my mandate. As you would recall, Your Worship, the state's theme, by the way, if my learned friend forgot, is that Mr. Mulunga used that tool to siphon money out of Namcor, and that money was then shared amongst the accused persons, the co-employees at Namcor. So I have every right, Your Worship, objecting and representing my client's interest in doing so, Your Worship. So God bless you.
Yes, Mr. Casper, you have the right to object, but if there is a witness, the court allows you on, once you put it on record as an officer of court, I cannot allow the issue to be discussed without an objection because I'm an officer of court.
I'm not sure.
I'm saying that the court has allowed you because often when you start, you are indicating as an officer of court, I cannot sit here and watch the injustice occur. It's on that basis that the court is allowing you to
And
proceed.
when I wrote
Before I proceed. Yes, so it's on that basis that the court is allowing you to proceed. But if the counsel for the applicant is here and he can object on that aspect.
Absolutely.
Yes,
And when
yes.
I wrote, Your Worship, I did so as an officer of this court, because what are we doing? Look when we started, Your Worship, and look where we are. If repetitive questions that have no relevance to moving forward is being asked, Your Worship, in the interest of continuing these proceedings, I have to object, Your Worship.
Yes, I understand that one. However, it appears that counsel for the respondent was not even finished with his question.
Then
Yes,
I
yes.
accept that, Your Worship. That's the court.
It's in order. Counsel, can you then finish your question?
Yes, so my question was, so the asset purchase agreement was just
Was that the commercial offer
Yes.
was just an enabling instrument? Maybe
Yes.
yes.
was just an enabling instrument for Namco to pay money to Enacom.
I flatly denied it, Your Worship. And I have demonstrated, I think during earlier testimony, that commercial offer was birthed from a fuel supply agreement between Enacom and Namcor Trading and Distribution. So it cannot be viewed in isolation. If it was just an agreement or offer that we plucked from the air and signed, maybe one could make that argument. But it was part and parcel of an agreement that we were supposed to execute further actions. Because that fuel supply agreement between Enacom and Namcor Trading and Distribution was incomplete without an asset purchase agreement. Because you can't enter into an exclusive supply agreement with a customer without an investment into the assets. I think that is what I explained 3 days earlier. So that is not correct.
So, Your Worship, of course, I had to allow the witness to answer the question, but it seems that during the evidence in the chief, maybe my colleague was absent mind, because, Your Worship, you recall, the witness took the court into the whole process, the asset evaluation process, by an expert committee of Namcor, by an independent person, engineers from outside, recommendation by various experts.
Counsel, I understand, but the question has already been answered.
No, what I'm trying to
Yes.
to Your Worship is we are repeating things which already has been answered. So if we can move forward to avoid being repetitive, Your Worship, that in essence was the essence of my objection. Please go to worship.
We can. Was it an objection, or you indicated from the onset it's not an objection?
Not an objection, just to make
To
sure
make
that
sure.
we don't
Okay.
repeat things which are clear on the record.
Then we can cancel.
Just having made an undertaking to you, I think I should also just caution my learned friend with the statement he made about the colleague for the state being absent-minded. I think
Yes.
that is slightly harsh, Worship.
Yes, cancel.
It's withdrawn,
Can we
Worship.
maintain our decorum? Yes, it's in order. It's in order. Yes, Mr. Casper, the court is indebted.
Yes, the court is.
Now, Mr. Mulunga, just to conclude, I would like to put it to you that had it not been for you as the mastermind or the architect of this whole scheme, these charges would not have been there in the first place. No one would have been charged here had it not been for you. In other words, you are the mastermind, you are the architect of this whole scheme.
Your worship, I do not understand why I can be labeled as the architect or mastermind of this whole scheme. As I am not the one that was managing director of Namcor Trading and Distribution, give orders downwards to say you guys must do. As a managing director, I'm not the one that initiates business transactions. Business transactions are initiated at departmental level. And I think it was proven through internal memorandums that were written to me, and even the fuel supply agreements. These things are done by the commercial department. And then they go through various levels at Namcor and then come to me. So for me to be accused as a mastermind is totally uncontroversial.
And I would also like to put it to you that in the execution of your duties as the managing director of Namcor, you dismally failed to exercise due diligence to run Namcor as a reputable institution. In fact, you ran it down the drain, sir.
That is not correct. Again, as I said earlier, when I came to Namcor in 2015, the revenue of Namcor was around 600 million. By the time that I left Namcor, the revenue of Namcor was 7.4 billion. So you cannot be somebody that sort of have a tenfold increase in a company's revenues and actually be regarded as somebody that drove the company down. There are various reasons why some of these things happen, especially the debts of Namcor. By the time that I was there, the debts were being managed. All these companies were trading with Namcor. Some of these companies were paying $30 million, $1 million per week to Namcor. However, since I left, things deteriorated. People stopped being supplied. People stopped paying. So that cannot be blamed on me. But by the time when I was there, we did not have these problems. Yes, there were issues of non-payment, people that were behind with their accounts, but it was being managed and people were paying. So I deny flatly the statement that is being made here.
And I would like to put it to you further that you said, due to the seriousness of these charges and also the amounts involved, you are not a good candidate for bail because of the charges that you are facing. If granted bail, you will abscond.
Oh, absolutely not. Why would I abscond? I am not going to abscond. Namibia is my home. I have been here. I have been investigated multiple times by Namcor. I have gone on disciplinary hearings. I have gone to courts. I have gone to labor matters. There is no reason for me to run away. I am ready to clear my name to show that I am not the result of the problems that Namcor currently finds themselves in.
In fact, it will also not be in the interest of the public or the administration of justice for you to be granted bail, because public funds had been squandered in the manner it was squandered, and therefore you should be kept in custody, sir.
Your Worship, those public funds were not squandered by me. I did not receive any cents from those public funds that you mentioned, and I don't even know what are the public funds that you're referring to. Yeah, I did not receive any cent, and if there are people that should be held liable or guilty for these funds, these are people that have not paid their accounts to Namcor, not me. And I am not the one that told them not to pay their accounts. So I totally disagree with that assertion.
I have no further questions, Your Worship.
Mr. Bangamwabo.
Mr. Mulunga, in the examination, let's start with the last aspect by State Counsel. He says it's in the interest of the public, or in the public interest, that you be kept in custody because the public funds have been squandered. Now,
Your Worship, it's not an objection, but just to complete the question, I say it in the administration of justice as well.
please go to your worship.
Counsel, are you finished? Or you can proceed.
Yeah, we are proceeding,
Yeah.
Your Worship. Now, is it correct that the public funds, I'm not sure if they're public funds, the funds being referred to are the outstanding debts which are owed to Namcor by various debtors, including Enacon, EcoFuel, or Erongo Petroleum. Correct?
Well, I'm not quite sure what he was referring to, Your Worship, but I assume that's probably what he is referring to. It's probably what is owed to Namcor.
What is owed to Namcor by the people who took fuel, by the companies which took fuel.
That's correct, Your Worship. So, I personally, Mani Mulunga standing here, did not squander any public funds or took any public funds from anybody.
Mr. Mulunga, we have seen various fuel supply agreements which you signed between Namcor, Enacon, Erongo Petroleum. And we have referred to you or to the court what will happen, what happens when either of the parties to that contract fails or refuses to comply with the contractual obligation. You remember?
I remember this one.
So let's go to one of those fuel supply agreements. Let's go to page, Your Worship, 185. That is the fuel supply agreement between Namcor Trading and the Enacon. Your Worship, from 185 to 210 of the bundle by the applicant. Are you there, Mr. Mulunga?
And then, Your Worship.
That is the agreement, Your Worship, dated 16 March 2022. Now, of course, you are being accused of giving free fuel or supplying fuel for free to some of the entities cited here. There is no evidence to that effect, but I want you to go to page, Your Worship, 200 of that document. I want you to look at page 14. No, paragraph 14.
Yes.
Yes. Can you read it into the record?
Breach and remedies. An event of default shall mean any of the following.
Yes.
The failure of the buyer to make any payment under this agreement.
Yes.
The failure of the either party to perform its obligations in relation to delivery or collection of the products.
Okay.
The failure of either party to comply with its other obligations under this agreement.
Yes.
Any representation or warranty made by either party under this agreement, if proved to be untrue when made in any material respect.
Very good. Let's stay with the 14.1.1.
Council, it's a re-examination. Where are you getting it?
Where am I getting it?
I'm saying, where are you going? It's re-examination. Why do you want to clarify that?
I want to clarify, Your Worship, because according to the state, is that Mr. Mulunga, as the ex-managing director of Namcor, must be kept in custody because of the debts of the contracting parties to the contract. I want to show to the court that the contract concluded between Namcor and the Enacon provides otherwise. Please go to Your Worship. Now, Mr. Mulunga, go to page with regard to the remedies. Let's go, Your Worship, page paragraph 14.3. Can you read that into the record?
Yes, Your Worship. Should the buyer fail to make payment when due, any and all payments due from the buyer to the seller shall become immediately due and payable, and the seller shall.
Yes. 14.3.1.
Shall entitle to.
I have to object to that line of question, because if Your Worship has a recollection in that this part was already dealt with by Mr. Bangamabo in examination in chief. So I don't know what is unclear. I think that's a point he can argue, because this document is here. It was dealt with extensively by Mr. Bangamabo when he was examining in examination chief of the client. So if he has any point to carry forth from this document, it's something that he can argue, because I think the document is there, the court is aware of the document. Mr. Court, please.
Any response?
For the sake of progress, I will rephrase my question. Mr. Mulunga, if you look at this contract, especially the remedies applicable, is there any provision which speaks to the fact that if any of the fuel supplier or the person who received the fuel fails to pay, that the managing director of Namcor must be arrested and kept in custody?
No, there's no such provision, Your Worship.
And then there is also an allegation that you failed to exercise corporate due diligence, which led to the whole scheme, the reason why we are here. My question is there any law in this country which provides for criminal prosecution, for arrest and criminal prosecution for violating or breaching corporate governance?
No. I'm not a lawyer, but I'm not aware of such law. In fact, in the relationships between employee and employer, there are remedies for non-compliance of contracts, and that is disciplinary action.
And when you testified 2 days ago during evidence in chief, you confirmed to the court that all policies of Namcor, including the credit limit policy and the schedule of authority policy, they form part and parcel of the employment contract.
That's correct, Your Worship.
You also confirm that if those policies are not complied with, then the disciplinary action must be taken by the employer, that is Namcor.
Yeah, that is what the contract says that I signed with Namcor, National Petroleum Corporation of Namibia.
Now, as far as you remember, Namcor as your former employer or through the board of directors, have they brought you before any disciplinary committee to face the allegation which are before this court? Especially in respect of asset purchase agreement of July 2022.
Well, they attempted to do so. In fact, they tried to join charges relating to this asset purchase agreement to an ongoing disciplinary matter I was facing. But obviously that was not accepted by the chairperson of the disciplinary committee at that stage. And when that was not accepted, Namcor went ahead and fired me unlawfully without actually going through a formal disciplinary process on these charges.
So you are telling the court that actually Namcor fired you without allowing you to explain the allegation against you in respect of asset purchase agreement.
That's correct, Your Worship.
Worship, can I talk to you because that is already suggestive of an answer. And these aspects were already dealt with in evidence in chief. So if he puts a position or position to a witness and just says yes, what is that? He's just leading him instead of seeking clarity. He's just telling him the answer.
Yes, Counsel, it's re-examination. Can we proceed?
Can we proceed, Your Worship? I want to be short. I wanted to finish before 1, but if my colleague keeps on standing up, of course it is right. He can keep on doing that. I can't stop him from exercising his right and representing his client.
Yes, he is within his rights. So we
Please,
can
Your
proceed.
Worship.
Yeah.
Mr. Mulunga, you heard the state saying that the asset purchase agreement was an enabler
Yes,
for the money which was paid to Enacon, which money then was shared among yourself as the applicant and the other co-accused. What is your answer to that?
No, that is not correct. I did not share any money with any other accused. And again, the asset purchase agreement was not a document that was signed in isolation. It was signed because there was already an agreement that actually suggested that the next step was supposed to enter into an asset purchase agreement.
Did you receive any money, any gratification or reward from Peter Elindi, from Elindi Malakia, that is on behalf of Enacon?
I did not, Your Worship.
On the issue of the motor vehicle, can you confirm to the court, you said you drove that car, that motor vehicle, the Audi Q8. Who is the owner of that car?
The owner of that car is Mr. Simaneka Victor Malima.
Victor Malima.
Yes.
Now, this Mr. Victor Malima, at the time the asset purchase agreement was being negotiated and later on concluded, do you still remember when it was signed?
Yes, I remember.
To assist I think it's common because it was, the last date was 18 July 2022.
That's correct, Your Worship.
Was Victor Malima part of the ENACON team which negotiated with you?
No, he was not, Your Worship.
To your recollection, was Victor Malima a shareholder or a director of ENACON at that time, July 2022?
No, not to my recollection. In fact, he was not a director of Enacon that I had dealt with at all.
Still on the motor vehicle, just to assist the court, and of course the state, do you remember or would you recall when that motor vehicle was bought? I know you didn't buy it, but just if you remember, if you don't remember it.
Yeah, I believe that motor vehicle was bought towards the end of 2023, Your Worship. Probably October or November or thereabout.
I'm asking this, Mr. Mulunga, because the state's case is that the money which was paid to ENACON, that is 53 million, 35 million paid back to Namcor, but there was a remainder of 18 million. And the state case is that part of that 18 million was used to buy this motor vehicle. Do you remember?
Yeah, I remember that too, Your Worship. In fact, Your Worship, I have a deal confirmation here, I think, between the bank and Mr. Simaneka, who bought this car, and looks like this car was financed by the bank. The date is the 23rd of August 2023. He paid a deposit for an amount of 957,000.
If you can slow down, because
Yeah.
the court is taking it.
Yeah, I mean, he paid the deposit amount of 957,974, 55 cents over a contract period of 72 months. So it looks like it is a hire purchase. The vehicle that he bought, or in fact, the deal was confirmed already on the 23rd of August 2023, which is more than a year later after the asset purchase agreement had been signed.
And that time you were no longer at Namcor, you were on suspension. If
Yes,
I'm correct.
I was on suspension, and in fact, I was actually, given a letter by Namcor on the 8th of August already, that my contract would be terminated.
8th of August, which year?
2023. No, that was 2024.
Yes.
Yeah.
But where were you in August 2023?
I was on suspension.
Okay.
I was not at Namcor.
Yeah, Your Worship, I gave the document the witness is reading from. I gave the same document to the state. So if there is no objection, we would want to hand up that document. Please go to Your Worship.
No, there is an objection based on the following. Firstly, Your Worship will recall that there's a document that relates to the same motor vehicle that we wanted to rely on, but it was disputed or cancelled for the accusing. In fact, all the legal representatives say it was not legible, despite that the fact that it's just one page of it that is not legible. And secondly, it's improper for counsel then to seek to introduce a document to the witness in re-examination. This document could have been introduced to this witness during his evidence in chief. Because in fact, one of the things that the counsel have taken issue with us is the disclosure of documents during the proceedings. This document was just disclosed to us this morning, and it's being introduced in evidence in chief, so in re-examination. So the short of our objection is that it's improper to introduce this document in re-examination, and secondly, council had the opportunity to deal with this document when the witness was here in evidence in chief. That will be short of our objection.
Any response?
Yeah, Your Worship, just in brief, I don't think it's appropriate for the state to say that we cannot hand up a document because their document was refused. That can't be, because their document was simply refused because it was not eligible. This document is eligible. It's clear. Number two, His Worship has made the ruling in respect of this handing up documents. It's not necessary to follow any procedure because this is a sui generis application, their application. And then number three, and more importantly, these documents is an answer to the questions or evidence solicited by counsel for the state during cross-examination. And it's in all fairness that the court have sight of this document to confirm what the witness spoke, because he spoke to the document. Please, the court will watch. That is my answer.
Now, it is apparent that such a similar document was already before court and attempts were made for the same and it was not received.
No, it's not the same document. It's a completely different document.
Yes, the court is proceeding, Counsel.
Yes, Your Worship.
Yes. Even if it's a completely different document, this is a bail application and it's not the trial. That issue can be dealt with in another forum. Therefore,
Please, the court, Your
the
Worship.
objection is sustained.
That's in order, Your Worship. Now, Mr. Mulunga, the state is accusing you of conspiracy and some kind of common purpose with you subordinate, you ex-subordinate. That is accused number 3, accused number 2, and accused number 4. Now, at the time you left Namcor, was there any complaint lodged by either of the mentioned accused person to Namcor board to the effect that you intimated them, you intimidated them, you commanded them, or you coerced them to do unlawful activities?
No, there was no such thing, Your Worship. In fact, I mean, the management style of mine is not the top-down management style, it's the bottom-up management style. So I am not the one that introduces transactions in business deals and force them upon the subordinates to go and carry out. In fact, it's the other way around. Where business deals come from the departments, get screened by the various departments through the legal department before they come to me for signature. That is how it was working.
It was also, Your Worship, to be a bit.
You can proceed. You can proceed.
There was also a reference by State Council that because you continue to give fuel to Namcor, knowing that they still owed money to Namcor, knowing that they've exceeded their limit. The limit, it was put to you 15 million, and you should be in custody, you should be arrested. What is your answer to that?
I mean, that is it's an unfortunate situation. that I should be arrested first and foremost for people that have not paid their debts. As I said, by the time that I was there at Namcor, the situation wasn't as dire as it became. During my time, obviously, we took the necessary measures to make sure that corrective action was taken in terms of debts and debtors. I think, however, when I left Namcor, and I think the directors of Enecon also left Enecon at that time, I think they left on the 23rd of February, I left on the 4th of April. The new people that sort of were in charge of the entities, obviously, maybe the relationship didn't work out so well between them, and there were cancellations and contract cancellations that, and I think there was maybe stopping of supply and maybe subsequent non-payments, but that has nothing to do with me. We entered into a business transaction in good faith. Obviously taking certain assumptions, and then unfortunately things didn't work out after we left, and they cannot be blamed on me as the managing director.
Yeah,
At that stage.
okay. Of course, during your evidence in chief, you went through meticulously the credit limit policy. You remember the roles and responsibilities and so on.
Yes.
In terms of that policy, is there any provision for criminal prosecution for anyone who violates or who does not comply with that policy?
No, there isn't. And again, as I said, if there was something like that in that policy or any other policy that suggests that criminal proceedings would, then I would have probably not taken that job. And I don't think anybody would want to take a job that actually make them sort of liable for criminal prosecution for, not following a policy or oversight of a policy.
Yes. Still on the giving fuel in excess of the credit limit. The PwC investigation report, Your Worship, I don't need to go there, but there is a paragraph to that. I think we saw that one.
You can proceed.
Yes, Your Worship. Now, Mr. Mulunga, that report recommended that this internal disciplinary action be taken against members of the credit committee. You remember?
I remember.
Now, to your knowledge, when you were still there, or after you have left, was there any disciplinary action taken by either the Namcor board against members of that committee, that the credit committee?
No, I don't believe so. I don't believe that there was actually disciplinary action taken against the entire credit committee. There could have been disciplinary measures against one or two individuals, but it was a large committee, and I don't believe that there was actually action taken against the credit committee that made the recommendation to the managing director.
May I proceed, Your Worship?
Yes.
Mr. Mulunga, is there anyone from that committee who is sitting here as an accused person?
Yeah, I think there are a few that were from that committee that are part of the accused person.
So, Namcor board failed to take disciplinary action, but then ACC arrested them for criminal prosecution.
Yes.
There was also a question by State Council with regard to the payment of 53 million to Namcor, and you also informed the court that, of course, there was an oversight because you ought to have informed the finance committee. The finance committee or the board?
The finance committee of the board.
Yes.
The audit and risk and finance committee.
Actually, you emphasized that it was some kind of mistake or oversight on your part.
Yes. I considered that that was probably the only oversight that was made, not to inform the finance committee that the reallocation that we've made from one budget vote to the other was actually higher than 25%. So therefore, we had to go to the committee to inform them and to get a blessing, but not necessarily for the transaction. So that there's a difference. It's not because I heard that I signed asset purchase agreement without board approval. I mean, you don't need board approval. I think we've actually demonstrated that you don't need a board approval to go and sign a contract. According to the schedule of authority, the MD has the authority to sign contracts at all
levels, any amount.
Yeah, any amount.
So we have seen that one.
Yes. However, when it comes to spending, I think that's where we needed to go to the finance committee to actually tell them that yes, the reallocation that we made from one budget vote to the other was higher than 25%. So give us the blessing so that we can continue. And that was an oversight. I take accountability for that. And I cannot say it's one individual person's mistake. So I am an honest person to actually say where I have made a mistake. But again, that mistake is not criminal mistake. It is where we mistook a policy directive that we didn't follow. But yeah, it's not. There's no criminal intent actually that was involved.
Please go to your worship. Now, before I go to, you said you drove the motor vehicle, the Audi Q8, for a couple of days. You remember?
Yes.
Can you be arrested for driving someone's car? If you have a friend or a colleague in this country, is there any law which prescribes that if Francois gives you my car, you don't know where I bought the car, for how I got the car, is it a crime for you to drive the car, someone's car?
No, I can't see how that is a crime just to drive somebody's car.
And then the state says that you will abscond because the charges against you are very serious. You heard that?
Yes, I heard that.
If you look at the evidence on record, what transpired, violation of policies, credit, authorities, and so on, what is your answer to that or comment?
No, I do not believe that these charges are serious, and I do not believe that we were supposed to be arrested for these charges. Yes, I concede that we should have probably been faced with disciplinary action, but I don't think these charges are serious that they should make me not to receive bail, so that I face the rest of the case, the rest of the trial. Because, again, Your Worship, as much as there is a case that Namcor is owed money by people who didn't pay, I myself did not receive money from anyone in the performance of my duties as Managing Director of Namcor Trading and Distribution or as Managing Director of National Petroleum Corporation. There is no such a case.
Is it, I mean, the state says the public funds. They say because you there are some public funds involved, millions. It's against public interest to release you on bail. You remember?
Yes, I remember that.
Is this public funds or contractual claims?
These are contractual claims.
Or contractual debts?
Yeah, that's correct. That's correct, Your Worship.
Is there any law in this country which says that if you are a managing director or an employee of any juristic entity and you sign a contract on behalf of that entity and that the other party does not comply with that contract, that you must be criminally liable?
No, unless I repeatedly say, if I knew that that is what can happen to me as a managing director, or anybody else sort of believe because of a result of this trial or bail denied, that you can actually be prosecuted for somebody that owes a company money and it doesn't pay. I mean, just give an example, if I may, Your Worship.
Please,
If I owe the municipality money and I don't pay, I mean, the CEO of the municipality cannot be arrested for my debts or any other company. I mean, if that was the case, I mean, this country would not be functional from a business point of view.
Now,
If I owe Truworths money and I don't pay, I mean, the managing director of Truworths cannot be arrested for that. There should be other measures to actually go and gather those outstanding debts instead of arresting and criminally prosecuting the head of such an institution.
now, Mulunga, I'm about to finish. Your Worship, Mr. Mulunga, if you look at the documents we have here, the evidence on record, you did not receive any money, no bank statement, no nothing. This is according to you, these are contractual debts, claims, and we know where they belong to. I don't want to go back there. Why, which instigated you in arrest, and as we speak now, you are in custody, when we all know that no one can be arrested for violation of disciplinary policies, for violating corporate governance issues, for debts owed to companies? Why? What do you think who is behind this, if you can tell that to the court?
I don't know, Your Worship. I really don't know. It's mind-boggling that really, one can simply be arrested without actually being afforded an opportunity to explain the situation. So I'm saying, if I was given an opportunity to explain to the HCC or whoever, I would have easily explained the situation. That I am not involved in siphoning or taking millions of public funds.
Yeah, to conclude, Your Worship, now, of course, I went through with you during the examination in chief, the bail condition and so on. Can you confirm on record that you would comply with any bail condition in the event that the court is satisfied that you are a good candidate for bail, that you comply with any bail condition imposed by this honorable court?
I can confirm that I'll go with any conditions that are imposed on me as far as the bail is concerned. Your Worship.
Is there anything which maybe you think, Your Worship, may I take instruction quickly?
You can proceed.
I'm checking something quickly, Your Worship.
Take your time.
Yeah, I think I'm done with you with the re-examination, Your Worship. Please quote, Your Worship. So that is the application for the fourth applicant, accused number 1. I have 2 bundles actually. The one on authorities, which I handed up during my opening statement. There is also a bundle which I handed up. I would request that they be marked as Exhibit E1. No, Exhibit B1, that will be the personal circumstances. E1. Because after Sister Namanje's bundles, there was D. So you can move to E. E1, E2, and 3 respectively, Your Worship. If there is no objection.
No objection, Your Worship.
None from our side.
There is no objection, Your Worship.
Can I have my bundle of part of the charge sheet? I don't have it.
Was it not given?
No, it was not given. It was not given. My exhibits together with the charge sheet. Officers,
So it was, I didn't have it this one, Your Worship.
court officials, you get the charge sheet together with the exhibits. Yes, it's only the charge sheet, the exhibits are not part.
It could be this one.
They're already marked, yes. They come together with the charge sheet.
I do not know how it ended up here.
It's the court officials, please, can we do our due diligence, the charge together with the charge. Yes, official, this is the court order. It's just lying loose. Yes, please. I'm going to call you to order. Please, can we do what we are supposed to do? Yes.
Please
That
continue.
is the court order. It's part of the charge sheet for yesterday, and it's just lying loose. We cannot allow that. Mr. Bangamama,
Yes, Your Worship.
the
There is a small bundle with the case law and some portion of the applicable legislation, Your Worship.
Yeah.
If that bundle be marked as Exhibit E1. And then there is a bundle prepared by ourselves relating to starting from page 1 up to page 346. That can be marked as Exhibit E2.
which bundle is that?
The bundle which we ended up with all the policies.
Yes.
Yes, Your Worship. That can be E2.
I want us to talk about the same. I have the file, which has been marked as Exhibit E1.
Oh, that
Is that the document you are referring to?
no, that should be
2300.
E2. There is a one small bundle.
Yes.
Front page Petroleum Exploration and Production Act.
Yeah.
That should be E1. And then the one which is His Worship marked the E1.
Then mark E2. And then the last one
is the personal circumstances for the applicant E3.
Just for the record, the document containing the statute starting with the Petroleum and Exploration Production Act of 1991, consisting of 39 pages, is marked as Exhibit E1. The file, consisting of about 346 pages, is marked as Exhibit E2, and the last Exhibit 3 is the one for personal circumstances of the first applicant, only 2 pages. So before you proceed, the court have a few questions to you.
Yes, Lord.
Can you just tell the court if you have any comment? Under what circumstances in your business relationship with a certain Mr. Victor Malema did you use his vehicle?
Yeah, firstly, I took it for a test drive. I suppose a vehicle that I was also interested in buying at some point. And secondly, he requested me to, on his behalf, to take the vehicle for service because he had fly out of town to Namcor, and he asked me for the vehicle.
Now, if you have any comment, is it fair to say that in the business or commercial transaction between Enecon and Namcor Trading, specifically with regard to the asset purchase asset purchase agreement that you played a key role?
I wouldn't describe it like that.
Now, in your evidence in chief, you dealt with this aspect, but just for clarity, did Enecon, after the coming into force, if I can use that word, of the asset purchase agreement, did Enecon deliver, or did Namcor take possession of the subject matter of that agreement?
Namcor took possession, meaning that they actually had the right to start using those facilities according to the agreement. Because after the effective date, then Namcor was then eligible to start making use of those assets.
Now, if you have any comment, it is apparent on the record from the evidence of the second applicant in these bail proceedings that it appeared that Namcor, or that there was confusion with Namcor regarding what they were buying. Do you have any comment?
No, there was no confusion from my point of view. Could be maybe confusion from other board of directors or other people, but as far as I'm concerned, there was no confusion as to what we were buying. It was very clear what we were buying. Well, yeah, maybe if I can just elaborate. It's possible the confusion could have come in after I left, or after the board of directors of Enecon had left. So clearly, those people that came maybe did not understand the original transaction. So maybe the confusion came from there. But when I signed the asset purchase agreement, there was no confusion for this, what I was signing or what the business arrangement was that we were entering.
It is apparent that Namcor did two, if I can use that word, for a lack of a better word, two valuations. One internal valuation of the asset and the second valuation by the consultants.
That's correct, Your Worship.
Now, during that process, was there any contact or communication between Namcor and the Ministry of Defense? If you have any comment.
I have no comment. I mean, there was no communication between certainly myself and the Ministry of Defense. I have had no business actually talking to the Ministry of Defense. So the answer is no, from my point.
Further, it is apparent from the evidence of the first applicant in these proceedings that page 277 of Mr. Namanje's bundle, it contains a list of the assets. Part of those assets is 83 cubic meter tank. The first applicant testified that that tank was not Enecon's asset, but the Ministry of Defense. He proceeded to testify that he was never consulted when the valuation was done regarding those assets. Do you have any comment?
Yeah, no, I did hear him talk about the 83,000 liter tank.
Yes.
Yeah, but I...
Yes, 83,000. Yes.
83,000.
Yes.
Yeah, no, I have no comment because I was not involved at all at that level. My involvement was really when I signed off the asset purchase agreement after my officials had gone through that and I satisfied myself that the recommendations were okay for me to sign.
So any follow-up questions, Council?
Yeah, Your Worship, maybe just as a follow-up question, if I may take His Worship to page 86 of our bundle, that is E2. Just as a follow-up to His Worship, question relating to evidence by the second applicant, which regard to the confusion, the alleged confusion as to what was being bought or sold. Your Worship, Mr. Mulunga, are you there?
Yes,
At page 86.
Yes.
This is, we deal with this, Your Worship, but I just want to draw the attention to the court of one asset purchase agreement in 1.1. Are you there, Mr. Mulunga?
Yes, I'm there.
Yes. Can you read it again?
Yeah, it is noted that there are differences in the interpretation ascribed to the asset purchase agreement dated 15 July 2022.
Yes, and this letter was written by who?
By Mr. Victor Malima from Namcor.
Yes, that was in July 2023.
Yes.
Yeah, now, the question I have for you, just as a follow-up, after there were some differences about who bought what, were you, for instance, contacted by maybe Namcor? Because I know that time you were on suspension.
Yes, I was already on suspension.
In order for you to explain these differences or this confusion?
No, I wasn't.
Because you remember, this is the letter of cancellation of that asset purchase agreement.
That's correct. Your Worship.
Please quote, Your Worship. That's from my side, Your Worship.
I do not have any question, Your Worship.
Sir, we thank you for your time. You may stand up.
Your Worship, I think we request a short adjournment. The next person, the application is by accused number 3. It will be very short, but we propose that we adjourn and then because I need to consult with the applicant for a few minutes, and then we can start at 2 o'clock sharp. Please quote, Your Worship, if there is no objection from my colleague.
Councillors,
No objection, Your Worship.
the court then adjourns until 1400 hours.
Right.